All right.
The Kosovo Specialist Chambers is now in session.
The photograph, yes. You have. I was told you have 1 minute and a half to take pictures. Thank you, Madam Photograph. So good morning and welcome, everyone. Madam Court Officer, could you please call the case?
Good afternoon, Your Honours. This is case file KSC CA 2022-01, the Specialist Prosecutor versus Hisni Guzzati and Nassim Haradinaj.
Thank you, Madam Court Officer. I note that Mr. Guzzati and Mr. Haradinaj are present in the courtroom. So now I will ask kindly the parties to introduce themselves, starting with the counsel for Mr. Guzzati.
Your Honour, I appear on behalf of Mr. Guzzati. I'm assisted by co-counsel Mr. Bowden and Ms. Stevenson, also assisted by Mr. Dashi, Mr. Hanalai, and Mr. Stephen Clark, BEM.
Thank you. Counsel for Mr. Haradinaj.
Good afternoon, Your Honours. I appear on behalf of Mr. Nassim Haradinaj today. I'm assisted by Ms. Bernabeu, Mr. Cubbon, Mr. Solomon, Mr. Barisha, and Ms. Koo.
Thank you. For the Specialist Prosecutor's Office, please.
Good afternoon, Your Honours. For the SPO today, Ward Ferdinandus, James Potch, Lena Peterson, and Matt Halling.
Thank you. I turn to the registry.
Good afternoon, Your Honours. Fidelma Donlan, Registrar, joined today by Mr. Ralph Roach, Head of Judicial Services Division.
Thank you. For the record, I am Michelle Picard, presiding judge in this case. On my left, Judge Nina Jorgensen, and on my right, Judge Kay Ambos. The Court of Appeals is sitting today to pronounce its judgment in public in the name of the people of Kosovo and in the presence of the accused. This case concerns the appeals against the trial panel's findings regarding the responsibility of Mr. Guzzati, chairman of the Kosovo Liberation Army War Veterans Association, and Mr. Haradinaj, deputy chairman of the same organization, in a series of events that took place during a 3-week period from 7 September 2020 until 25 September 2020. On 18 May 2022, the trial panel delivered the trial judgment convicting each of the accused for criminal offenses against public order and criminal offenses against the administration of justice and public administration. The accused were found guilty on 5 counts of the indictment, count 1, 2, 3, 5, and 6, and not guilty on 1 count, count 4. The trial panel sentenced each of the accused to a single sentence of 4.5 years of imprisonment with credit for the time served and a fine of €100. The trial panel found that during the indictment period, the accused received from unknown sources 3 sets of documents containing confidential and non-public information related to the work and investigations of the Special Investigative Task Force known as the SITF and the Specialist Prosecutor's Office known as the SPO. This material was delivered to the premises of the Kosovo Liberation Army War Veteran Association on 7 September 2020, 16 September 2020, and 22 September 2020. After each delivery, the accused called and hosted a press conference where they discussed and made available to journalists each of the sets of documents. During the same period, the accused, individually or jointly, gave a number of media interviews regarding this material. They also commented on the material and republished articles on social media. What was left from the sets of documents was subsequently handed over to the SPO and identified as batches 1, 2, 3, and 4, referred to as the batches. Before I summarize the findings of the panel in this case, the panel wants to stress that the specialist chambers were created in connection with serious allegations of inhuman treatment, killing of people, and other serious crimes during and in the aftermath of the armed conflict in Kosovo. Prior to the establishment of the specialist chambers, several impediments to the discovery of the truth by other courts and tribunals about these events have been of ongoing concern. These included the reluctance or fear on the part of witnesses to testify and their lack of confidence in protective measures. The panel recalls that it is precisely in that context that the specialist chambers were established in order to ensure secure, independent, impartial, fair, and efficient criminal proceedings in relation to these allegations of serious crimes. The nature of the crimes under the jurisdiction of the specialist chambers and the context in which they were committed necessitate reliance upon oral evidence. It is fundamental to the fulfillment of the specialist chamber's mission that individuals who come to give evidence, often about traumatic or difficult experiences, may do so without fear. The protection of the witnesses from intimidation and harm lies at the very foundation of any system of criminal justice, including the specialist chambers. This case concerns, therefore, the proper administration of justice, the integrity and security of proceedings, and the safety of witnesses. I will now read a summary of the central findings of the panel. This summary is not the part of the appeal judgment, nor it is authoritative. The written judgment is the only authoritative account of the panel finding. Both Mr. Guzzati and Mr. Haradinaj filed an appeal challenging their convictions under count 1, 2, 3, 5, and 6 of the indictment, and further challenged the number of related findings made by the trial panel. They also both challenged their sentence. Mr. Guzzati's appeal comprised 20 grounds and various subgrounds, and Mr. Haradinaj's appeal comprised 24 grounds and various subgrounds. On behalf of the panel, I will first summarize the findings of the panel on the alleged errors concerning fair trial and evidential issues. I will then summarize the panel's findings related to the appeals on count 5, 6, 3, 1, 2, and turn next to the defenses and grounds excluding responsibility raised by the accused. I will conclude with the sentencing appeals. In a preliminary section dealing with fair trial and evidential issues, the panel addresses Mr. Guzzati's and Mr. Haradinaj's alleged errors concerning the trial panel's decision not to disclose or to redact some of the material contained in the batches. The panel finds that the documents contained in the batches are not relevant for their content, but for their confidential nature. Considering that the documents contained in the batches formed part of ongoing SPO investigations, The panel finds that it was reasonable to order that an SPO investigator would confirm the confidential status of the documents as a counterbalancing measure for the non-disclosure of part of the batches. The panel further observes that the defense had the opportunity to cross-examine the SPO investigator, witness W04841, and that in addition to this evidence, the trial panel established the authenticity and confidential nature of the batches by relying on several other sources. The appeals panel finds that the accused have failed to demonstrate an error in the trial panel's findings. Turning to the trial panel's determinations, at hearings ex parte the defense on material allegedly relevant to the claim of entrapment, the panel considers that the procedure followed by the trial panel when assessing the SPO's request under Rule 108 of the rules met fair trial standards. The panel therefore rejects Mr. Ahadinai's contentions. The panel turns to Mr. Ahadinai's argument that the trial panel erred in refusing to accept submissions after the closing of the case regarding allegations made by Mr. Dick Marty. The appeals panel finds that Mr. Ahadinai failed to demonstrate an error in the trial panel's conclusion on the absence of any link between this material and the present case. Other challenges related to fair trial and evidential issues are addressed in the appeal judgment. I, on behalf of the panel, will now turn to appeals on count 5, 6, 3, 1, and 2 of the indictment. The parties set out detailed arguments regarding alleged errors by the trial panel on the material and mental elements of the offenses, and the panel will summarize the main findings. Count 5 of the indictment pertains to the offense of violating the secrecy of proceedings through the unauthorized revelation of secret information disclosed in official proceedings, punishable under Article 392, Paragraph 1 of the Kosovo Criminal Code. The accused challenged the trial panel's finding on the actus reus of this offense. The panel will start with the accused's challenges concerning the findings that the protected information was revealed without authorization. Mr. Guzzati submitted that disclosure of confidential information in the public interest or by a whistleblower is permitted by law. The panel, however, finds that these defenses may exclude criminal liability but would not affect the actus reus of the offense under Article 392, Paragraph 1 of the Kosovo Criminal Code. These arguments are therefore irrelevant to assess challenges to the actus reus of this offense. Mr. Guzzati submitted that the perpetrator of the offense can only be the initial recipient of the information, meaning the SPO or its counterpart. The panel dismisses Mr. Guzzati's interpretation and agrees with the trial panel's finding that Article 392, Paragraph 1 of the Kosovo Criminal Code does not specifically require that the information must have been disclosed directly to the perpetrator of the offense. With regard to the nature of the protected information, the panel recalls that Article 392, Paragraph 1 criminalizes two alternatives. First, the unauthorized revelation of information which must not be revealed according to law, and second, the unauthorized revelation of information that has been declared to be secret by a competent authority. The panel has assessed the accused's argument in relation to the second alternative. Regarding the interpretation of the term secret, the panel finds that Mr. Guzzati failed to demonstrate that the trial panel erred in finding that information treated as confidential by the SPO had to be regarded as secret within the meaning of Article 392, Paragraph 1 of the Kosovo Criminal Code. In addition, contrary to Mr. Guzzati's assertion, the legal framework of the specialist chambers contains no obligation for the SPO to prove that the information was lawfully and rightfully classified as secret. Having rejected the challenges to one of the two alternatives under Article 392, paragraph 1 of the Kosovo Criminal Code, the panel did not address the challenges to the fulfillment of the other alternative, namely whether the protected information also qualifies as information which must not be revealed according to law. In conclusion, for these counts, the appeal panel dismisses the defense challenges to the trial panel's finding in relation to count 5. Turning to count 6. Count 6 of the indictment pertains to the offense of unauthorized revelation of the identities and personal data of protected witnesses, punishable under Article 392, paragraph 2 of the Kosovo Criminal Code. The accused challenged the trial panel's finding on the actus reus of this offense. The panel will start with the accused challenges to the findings on person within the context of the formulation person under protection in the criminal proceedings. The panel finds that the defense failed to demonstrate any error in the trial panel's finding that, for the purpose of count 6, the term person covered the witnesses and potential witnesses as defined by the SPO investigator, witness W04841. The panel turns next to the accused's challenges to the findings on the second part of the formulation, that is, under protection in the criminal proceedings. Mr. Guzzati argued that the protection must be granted rather than assumed. Both accused further argued that the trial panel wrongly considered that all persons named within the SITF and SPO documents were ipso facto protected. The panel finds that the reference in the Kosovo Criminal Code to under protection in the criminal proceedings does not necessarily require a judicial order and can also entail measures of protection adopted by the SPO during its investigations. These measures do not necessitate the fulfillment of the requirements mentioned by the accused, including a judicial order granting the protection, the identification of each of the persons concerned, or the consent of the person in respect of whom the protective measures are sought. The panel is further mindful that count 6 of the indictment pursuant to Article 392, paragraph 3 of the Kosovo Criminal Code provides for 2 aggravated forms of the basic offense. Only one aggravated form is relevant for this case, which is where the offense in Article 392, paragraph 2 resulted in serious consequences for the person under protection. The accused challenged the trial panel's finding on the actus reus of this aggravated form. The panel finds that the accused failed to demonstrate that the trial chamber erred in relying on the testimony of SPO witness W04842. The panel further finds that Mr. Guzzati failed to demonstrate why the trial panel's reference to substantial interference instead of serious consequences in the applicable law section of the judgment would constitute an error. Ultimately, the trial panel explicitly referred to serious consequences in its findings on Article 392, paragraph 3 of the Kosovo Criminal Code. Mr. Guzzati further challenged the trial panel's finding in relation to the witnesses at risk. For the reasons developed in the appeal judgment, the appeal panel finds that the trial panel did not err in finding that serious consequences occurred for the witnesses who were relocated and subjected to emergency risk planning. However, the panel finds that this finding can only apply to the 2 witnesses who were relocated. Turning next to the person identified in the confidential version of the trial judgment. I'm referring here to the person who had made public his cooperation with prosecutors investigating alleged offences committed by KLA members. The appeal panels find that the findings on this person's fear and concern resulting from being publicly named as a witness are not based on the available evidence in this case. The trial panel provided no explanation supporting its finding and did not further explain whether it considered that a complaint about the publishing of the leaked documents would amount to a serious consequence. Accordingly, the appeals panel agrees with Mr. Guzzati that the trial panel erred in relation to this specific finding and therefore grants ground 11 of Mr. Guzzati's appeal. Any impact on this finding on the sentence will be discussed in a moment. In conclusion, for this count, the appeals panel grants Mr. Guzzati's ground 11 and the panel dismisses all the other challenges to the trial panel's findings in relation to count 6. The panel turns now to count 3. Count 3 corresponds to the offense of intimidation during criminal proceedings, punishable under Article 387 of the Kosovo Criminal Code. The panel will start with the accused challenges concerning the actus reus of the offense. The appeals panel preliminarily considers that it is clear that the trial panel found that the accused were guilty under the first alternative of Article 387, namely having used serious threats to induce someone to refrain from making a statement. The panel first turns to Mr. Guzzati's argument that the trial panel erred by finding that the last part of Article 387 of the Kosovo Criminal Code, stating when such information relates to obstruction of criminal proceedings, only qualified the third alternative of Article 387, namely the person failing to state true information to the police, a prosecutor, or a judge, and not the first alternative. For the reasons set out in the appeal judgment, the appeals panel considers that the words obstruction of criminal proceedings do not apply to the first alternative of Article 387, and therefore that the trial panel did not err by not finding that the accused used serious threats in relation to the obstruction of criminal proceedings. Regarding the definition of serious threats, the panel considers, with respect to Article 387 of the Kosovo Criminal Code, that the legislator intended this term to encompass any serious threat of harmful actions, not only a threat to use force. The panel further considers that, regarding Mr. Guzzati's argument that the threat implies that some harm will be inflicted in the future, the trial panel indeed made findings that persons will suffer harm as a result of the accused conduct. Regarding Mr. Guzzati's argument that the trial panel erred by finding that Article 387 of the Kosovo Criminal Code does not require proof that the serious threat did in fact induce a person to refrain from making a statement, the panel considers, for the reasons included in the appeal judgment, that the trial panel's interpretation is consistent with the wording of the provision and is in line with its purpose. Regarding Mr. Haradinaj's argument that his statements were not express or inferred threats, the panel considers that, for the reasons laid out in the appeal judgment, Mr. Haradinaj fails to show that no reasonable trio of fact could have reached the conclusion of the trial panel that the accused's acts and statements amounted to a serious threat. The panel turns to Mr. Guzzati's argument concerning the trial panel's reliance on the evidence of the SPO investigator, witness W04841, in relation to count 3. The panel recalls its earlier finding that the trial panel did not err regarding the non-disclosure of the batches. The panel also considers that the fact that the accused publicly identified only 6 individuals does not reduce the scope of revelation or impact the finding that the actus reus of the offense is established. Regarding Mr. Haradinaj's challenges to the methodology of the SPO investigator, witness W04841, the panel, based on the reasons set out in the appeal judgment, does not consider that the trial panel erred in its assessment of her analysis of the witness lists. In light of the above, the appeal panel finds that the accused have failed to demonstrate an error in the trial panel's assessment of the actus reus of the offense under count 3. The panel will turn next to Mr. Guzzati's challenges to the trial panel's finding on the mens rea of Article 387 of the Kosovo Criminal Code. First, the panel considers that the findings that Mr. Guzzati and Mr. Haradinaj possessed the direct intent to use serious threat to dissuade witnesses and potential witnesses from giving evidence to the specialist chamber or the SPO are reasonable. Regarding Mr. Guzzati's argument that a mens rea finding was required as to the truthfulness of the information to be provided by witnesses under Article 387, the panel recalls that failing to state true information is only part of one of the three alternatives under Article 387, and, most importantly, one under which the accused were not convicted. Therefore, there was no error by the trial panel. Based on the fact that direct intent was established, the appeal panel finds that Mr. Guzzati's argument that eventual intent is not sufficient to sustain a conviction under Article 387 are hypothetical and would have no impact on the findings. Lastly, the appeals panel finds that the trial panel specifically addressed Mr. Haradinaj's alternative interpretation of the evidence regarding direct intent and therefore did not err. In light of this, the panel finds that Mr. Guzzati and Mr. Haradinaj failed to demonstrate any error in the trial panel assessment of the mens rea of the offense of intimidation during criminal proceedings. In conclusion, the appeals panel dismisses the defense's challenges to the trial panel's finding in relation to count 3 and will turn now to count 1. Count 1 of the indictment pertains to the offense of obstructing official persons in performing official duties by serious threat, punishable under Article 401, paragraph 1 and 5 of the Kosovo Criminal Code. The panel will start with the accused's challenges concerning the actus reus of the offense. Regarding the definition of serious threat, the panel considers that the legislator intended this term to encompass any serious threat of harmful actions, not only a threat to use force. Regarding the direction of serious threat, the panel, Judge Ambos dissenting, agrees with the trial panel's finding that nothing in the language of this provision requires that the serious threat be specifically directed at the official person. The appeals panel also considers that the trial panel's interpretation is in accordance with the rationale of the offense, which is not to protect the official person as such, but rather to protect them in the exercise of their official duties. Accordingly, the panel, Judge Ambos dissenting, finds no error in the finding that the offense under Article 401, paragraph 1 of the Kosovo Criminal Code is established in this case, where the serious threat is directed against those who gave evidence to the specialist chamber or the SPO or who were likely to do so. Regarding Mr. Guzzati's argument that the exercise of force or serious threat must be simultaneous with the exercise of official duties, the panel considers that such interpretation would be inconsistent with the protection of this article. This article aims to afford to the safety of the performance of official duties and is not based on the text of the provision. In light of the above, the appeals panel finds by majority that the accused have failed to demonstrate an error in the trial panel's assessment of the actus reus of the offense under count 1. The panel will turn next to Mr. Guzzati's challenges to the trial panel's finding regarding the mens rea of this offense. The appeals panel considers that although the trial panel did not verbatim repeat the legal standard in its conclusion on the accused's intent, it made the appropriate findings elsewhere in the trial judgment, namely that the accused intended the use of serious threat against witnesses and potential witnesses as the means with which to achieve the result of obstructing specialist chambers or SPO officials in performing their work. In light of this, the panel finds that Mr. Guzzati failed to demonstrate an error in the trial panel's assessment of the mens rea of the offense under count 1. In conclusion, the appeals panel, by majority, dismisses the defense's challenges to the trial panel findings in relation to count 1. The panel will now address Mr. Guzzati's and Mr. Haradinaj's grounds of appeal concerning the relation of concurrence between count 1 and 2, namely the offences of obstructing official persons in performing official duties by force or serious threat, and obstructing official persons in performing official duties by common action of a group. The trial panel applied the cumulative convictions test, which has been applied by the ad hoc international criminal tribunals and allows for criminal convictions under different statutory provisions if each statutory provision involved as a materially distinct element not contained in the other. On the basis of this test, the trial panel convicted the accused under both counts 1 and 2. However, for the reasons explained in the appeals judgment, the appeals panel considers that the cumulative conviction test from the international case law applied by the trial panel is not appropriate in the specific circumstances of the case. The panel decided to rely rather on the civil law concept of concurrence. In this regard, it considered, inter alia, that the distinction in terms of the minimum punishment between the two provisions can be explained by the fact that the first paragraph of Article 401 of the Kosovo Criminal Code requires specific individual actions of obstruction, while under the second paragraph it would generally not be possible to establish the specific individual actions of obstruction committed by an accused. In light of this, the panel considers that the relation between these two provisions is best captured by the rule of subsidiarity, and that in this case, where the accused's individual acts have been specified and the accused have been convicted on the basis of Article 401, paragraph 1 of the Kosovo Criminal Code, a further conviction for Article 401, paragraph 2 is neither warranted nor necessary. Accordingly, the panel grants Mr. Guzzati's ground 16 and Mr. Haradinaj's ground 3, in part, decides that the accused can only be convicted under count 1 of the indictment and enters a verdict of acquittal under count 2 of the indictment. The impact of this finding, if any, on the accused's sentence will be addressed in a moment. In light of this finding, the panel finds that it is unnecessary to address Mr. Guzzati's argument regarding count 2 and his allegations of errors on the part of the trial panel regarding the actus reus and the mens rea of Article 401, paragraph 2 of the Kosovo Criminal Code. The panel will now address Mr. Guzzati's and Mr. Haradinaj's challenges regarding defenses and grounds excluding responsibility. At trial, the accused put forward a number of defenses and grounds excluding responsibility for their conduct. The trial panel, however, found that the criminal responsibility of the accused could not be excluded by any of the defenses or grounds excluding responsibility raised. In their appeals, the accused challenged the trial panel's findings, rejecting the arguments they presented in relation to public interest, whistleblowing, entrapment, extreme necessity, and act of minor significance. For the reasons developed in the appeal judgment, the panel rejects all the accused ground of appeal on these points. The panel will not summarize in details each of its findings. The panel will, however, address specific issues of interest in this summary. First, regarding the defense of public interest, the panel acknowledges that several of Guzzati's arguments pertain to the standard and burden of proof for grounds excluding criminal responsibility, and this specific standard requires particular attention. With reference to several sources, the panel clarifies that there is a difference between the SPO's burden to establish the guilt of the accused beyond reasonable doubt, burden of persuasion, and the defense's responsibility to present evidence to substantiate the grounds excluding criminal responsibility, burden of production, or evidential burden. Second, regarding the claim of entrapment by the SPO, the panel is aware that the parties have devoted lengthy submissions on this matter that has been extensively litigated both at trial and during the appeal phase of these proceedings. The panel notes that the trial panel correctly found that provided that the accused allegations are not wholly improbable, it falls on the prosecution to prove that there was no entrapment, as well as correctly identify the court's obligation to examine the facts of the case and take the necessary steps to uncover whether there was any entrapment. In line with this jurisprudence from the European Court of Human Rights, the trial panel did not err in referring to a requirement of prima facie evidence. The appeals panel further finds that the defense misconstrues the applicable standard from the jurisprudence from the European Court of Human Rights when arguing that the not wholly improbable standard is so low that it excludes any evidential requirement on behalf of the defense. For these reasons, as further detailed and developed in the appeal judgment, the appeals panel finds that Mr. Guzzati and Mr. Haradinaj failed to demonstrate that the trial panel erred in finding that the entrapment claim they raised was wholly improbable and unfounded. The panel will now address Mr. Guzzati's and Mr. Haradinaj's challenges related to sentencing. The panel first turns to Mr. Guzzati's challenges to the trial panel's assessment of gravity. As further developed in the appeal judgment, the panel considers that the trial panel did not err in its findings on gravity and the scale on which the accused committed the offenses charged. The panel turns to Mr. Guzzati's argument that the trial panel erred by failing to appropriately reflect in sentencing Mr. Guzzati's specific role in comparison to Mr. Haradinaj's under count 3. The panel considers that the trial panel carefully assessed the evidence and all of the relevant factors comprising sentencing, including Mr. Guzzati's role in the offenses in comparison with Mr. Haradinaj's. Thus, the panel finds that Mr. Guzzati failed to demonstrate any error in the trial panel's determination of his sentence in relation to count 3. As reasoned further in the appeal judgment, the panel also dismissed Mr. Haradinaj's challenges regarding the trial panel's findings in sentencing on the climate of witness intimidation in Kosovo and on Mr. Haradinaj exercising his right to free speech. The panel considers that, as discussed further during the appeals hearing, consistency in sentencing is important, but must allow for the trial panel's exercise of discretion regarding the individual facts of each case. As developed further in the appeal judgment, the panel considered the relevant domestic Kosovo cases and relevant cases from international courts and tribunals submitted by the parties. The panel is cognizant of the variations in the sentences imposed in international criminal courts and tribunals as compared to the sentences in this case. However, the appeals panel cannot ignore the specific facts of this case, viewed within the context of the applicable Kosovo legal framework and the sentencing ranges of the Kosovo Criminal Code. Considering the seriousness of the accused offences, the appeals panel finds that the trial panel did not err in its determination of the accused sentences on the basis of the convicted counts. The panel further found that the trial panel's error it identified in count 6 in relation to the aggravated form of the offence had no impact on the sentence. However, the appeals panel recalls its earlier findings on count 1 and 2, in which it reversed Mr. Gutsati's and Mr. Haradinai's conviction under count 2. As a result, the panel considers that the single sentences imposed by the trial panel should be reduced. For the reasons developed in the appeal judgment, the panel, Judge Ambos dissenting, finds that the single sentence for Mr. Gutsati and Mr. Haradinai each shall be reduced by 3 months to a single sentence of 4 years and 3 months of imprisonment. Judge Ambos concurs with the reasoning and conclusions of the appeals panel in relation to count 3, 5, and 6. He further agrees with the appeals panel reasoning on the relationship of concurrence between paragraph 1 and 2 of Article 401 of the Kosovo Criminal Code, count 1 and 2. Judge Ambos, however, disagrees with the majority with respect to its interpretation of the Actus Reus of Article 401, paragraph 1 of the Kosovo Criminal Code. Therefore, on this basis, he would have acquitted the accused in relation to count 1 of the indictment and would have reduced the single sentence imposed on them to 4 years. I would like to ask now Mr. Gutsati and Mr. Haradinai to stand while I, on behalf of the panel, read the full text of the disposition of the appeal judgment. You can stand, no problem? Yes. The Court of Appeal panel, pursuant to Article 46 of the law and Rule 182 and 183 of the rules, grants Mr. Gutsati's ground 11, 16, and 20 in relevant part, and Mr. Haradinai's ground 3 in relevant part and 24 in relevant part. Dismisses Mr. Gutsati's and Mr. Haradinai's appeals in all other respects. Reverses Mr. Gutsati's and Mr. Haradinai's conviction for obstructing official persons in performing official duties by participating in the common action of a group under count 2 of the indictment. Affirms that Mr. Gutsati's and Mr. Haradinai's conviction for intimidation during criminal proceedings under count 3 of the indictment, violating secrecy of proceedings through unauthorized revelation of secret information disclosed in official proceedings under count 5 of the indictment, and violating secrecy of proceedings through unauthorized revelation of the identities and personal data of protected witnesses under count 6 of the indictment, and further affirms Judge Ambos dissenting Mr. Gutsati's and Mr. Haradinai's conviction for obstructing official persons in performing official duties by serious threat under count 1 of the indictment. Sets aside the single sentence and 4.5 years of imprisonment imposed on Mr. Gutsati and Mr. Haradinai, and imposes, Judge Ambos dissenting, a single sentence of 4 years and 3 months of imprisonment on Mr. Gutsati with credit for the time served, and a single sentence of 4 years and 3 months of imprisonment on Mr. Haradinai with credit for the time served. Affirms Mr. Gutsati's and Mr. Haradinai's additional sentence to pay a fine of 100 euros. rules that this judgment shall be enforced immediately pursuant to Rule 185, paragraph 1 of the rules, and orders that in accordance with Article 50, paragraph 1 of the law and Rule 166, paragraph 3 of the rules, Mr. Guzzati and Mr. Haradinaj shall remain in the custody of the specialist chambers pending the finalization of the arrangements for their transfer to the state where their sentences will be served. Mr. Guzzati and Mr. Haradinaj, you may be seated. The registry shall now distribute the appeal judgment in electronic form and provide certified copies of the English version to Mr. Guzzati and Mr. Haradinaj. The Albanian version shall be served on them once it is ready. So I note that the certified copies have been distributed to Mr. Guzzati and Mr. Haradinaj, and this concludes the appellate proceedings in this case. The court stands adjourned.
All rise.